when the law changed in 2017, it resulted my colleagues and myself, pushing the legislature to mandate videotaping of interrogations. When the law came out, it came out watered down, and so they made exceptions for sex offenses, drug cases, and murder cases. And that really makes no sense, because those are the cases where we need it the most. That's what happened to me. So right now, the foundation, we do our policy work through the coalition group. It could happen to you. And the policy work that we're doing now, we're trying to get rid of those exceptions. So that's one initiative in New York. Another thing in New York is there's what's called the Youth Interrogation Act. And so that's a bill that says that it recognizes that people who are 16 and 17 years old, like I was, we don't understand our rights. So an attorney would have to explain our rights to us prior to being able to waive the rights and speak to the police. So there's that. And then there's a police deception bill, which would prohibit the police from using deception in the course of interrogations, recognizing that deception is inherently coercive. So those are three things in New York. Another one is called the Challenging Wrongful Convictions Act. So in a nutshell, the reason I had to write letters for 4 years is because you don't have a right to an attorney in a post-conviction proceeding. So the Challenging Wrongful Convictions Act would give people an attorney to do the investigation and file the motion, and it would also recognize that sometimes innocent people plead guilty. It's been estimated that 10% of people who are arrested plead guilty. So the way that it is now, so I have a client now, Omar Clark, and Omar was wrongfully convicted of an attempted rape in Erie County, New York. We're litigating the case now. So he was incarcerated, pre-trial detention, pending his trial, and for between 6 to 8 months. And he kept telling his attorney what witness to speak to, protesting his innocence. The attorney never spoke to the witness, never did any other investigation, and kept telling Omar, you're going to be found guilty of a rape. You're going to get 25 years. So why don't you just take the 7-year offer? And on the eve of trial, he was scared and had no confidence in his attorney, and he pled guilty. Subsequent to that, has a new attorney that's representing him, and then I entered the case as co-counsel. And so a ton of new evidence has come up towards his innocence. We're not allowed to argue in court that he's innocent. We have to argue, because he pled guilty, we have to argue that he had ineffective assistance of counsel, inadequate investigation. Here's what would have become up otherwise, and that's crazy. I have to jump through those hoops. So the Challenging Wrongful Convictions Act would allow people to make an actual innocence claim, a newly discovered evidence claim, even if you've pled guilty.
Why is the system set up to where so many people, I think it's like high 90% of people, take pleas and don't actually fight their case in situations like this? Like, that is the system. That's the way it works. Why is it like that? Is it because of lack of resources?
Yes, I think it's lack of resources. And many people even estimate it higher, 95, 97, even 98. I've seen these different percentages. I think it is lack of resources. I mean, literally, if everybody would insist on, exercising their right to a trial, the whole system would grind to a halt. So it's just
it costs too much money, right?
It would be, well, I don't know that it would cost too much money. I think that it's more money than what society is willing to pay. But the other thing, though, I want to mention, though, one of the reasons why the average length of wrongful incarceration, at least in the DNA case, is 14 years, is because there's a couple of tensions in the system. So one of them is finality of conviction versus accuracy, meaning the competing ideas that, look, you had your day in court, you lost, how long are we going to keep going through this? So in a way, having a finality, we can't keep going through this all the time. So in a way, finality makes sense in a way. But what good is a final conclusion if that conclusion is not accurate? So I think whenever there's an objective reason to revisit something, it should be. But then another thing is what I'll call proceduralism versus substantive justice. So why should it have mattered if my petition arrived 4 days late? Shouldn't it have been, well, am I innocent? Am I guilty? Are my legal arguments correct, or are they not? rather than the court deciding my case that 4 days, being late 4 days, a lateness caused by the court clerk was the key thing. So I feel like a lot of judges are not willing to overturn convictions. They're thinking about, well, we're undoing all the time and money that went into something in the first place. So sadly, a lot of times, whether or not a case can receive justice or not is not whether the defendant has the facts or law on their side. It's instead whether something's going to be rubber stamp denied or not. So those issues in New York that I mentioned, a couple of parole issues. So what's called fair and timely parole. So when I went to the parole board, they were in the habit. They denied me because I maintained my innocence, and also, they rubber stamp denied because I was charged with a violent crime. There's a lot of people are just denied no matter what type of rehabilitation they can show. They're denied anyway just by nature of the crime. But that's really counterproductive because, first of all, the nature of the crime is something that could never change. That was known before the first day in prison was solved, and that's almost a complete abandonment of any idea of a belief in rehabilitation. So fair and timely parole would mean that the parole board would have to cite an additional factor in denying parole beyond that, not based solely on that, as what happened to me. Companion bill called elder parole. So, according to the Department of Corrections, when you're 55 years old, you're considered to be elderly just because of the impact of being in prison has on the body. So if anyone who is 55 and has served 15 years minimum would be guaranteed a parole board appearance, not a release, but an appearance, just to be considered whether you could demonstrate rehabilitation or not. So those are the things I'm working on in New York. We did pass the Commission on Prosecutor Conduct. So the first in the country, independent commission designed to investigate and review allegations of prosecutor misconduct, recognizing that that's a cause of wrongful conviction that runs through many of the cases, and that the prosecutors have almost no oversight. So we passed that. I'm trying to get the legislature now to pick the people that are going to serve on their commission. So we got the governor to put $1.75 million in the state budget for the commission, and we passed it. But we need the commissioners to be named so it can start doing its work. That's in New York. In Pennsylvania is one of the 12 states, along with New Mexico being another one, that does not, they don't compensate people there. So the coalition group could happen to you. We have our Pennsylvania chapter. So I'm active in our Pennsylvania, New York, and California chapter. So we're working on in PA as we're building support for exonerated compensation. And when we pass that, the next thing is we'll try to export that oversight of the prosecutors to Pennsylvania. In California, we're working on trying to get that oversight for the prosecutors. So that's what's going on the policy front. And we talked about changes, and in this next year alone, we could possibly free between 2 to 11 people in terms of the 17 cases that are active.